My name is Candida Steel, and I'm retired as a judge on the U.S. Civilian Board of Contract Appeals. I handled federal government contract disputes around the country, and I'm from Annapolis, and I've been doing this program for about 20 years. And Ben?
Sure. My name is Ben Glickman. I'm a supervising deputy attorney general with the state of California. Much more importantly, I'm an alumnus of We the People and was lucky enough to be on a national championship team back in 1995. And you can see we're in the House Intelligence Committee room this afternoon. So it's just like being on Capitol Hill.
And hi again, my name is Marcia Holland. I'm here in Missoula, Montana. I was a career public defender in Alaska, but upon moving to Montana, I now teach at the law school. And I have been involved in this program both in Alaska and Montana for a number of years. And I'm so happy to see you all here.
Great. And would you introduce yourselves, please?
My name is Megan Steinmasel.
My name is Chris Steinmasel.
I'm Sammy Spitzer. We are from Laurel High School in Laurel, Montana, and we're representing Unit 3, and our teacher is Mr. Demi.
Welcome to all of you. And I'll read the question for the purposes of having it clear in the recording. In 2020, we celebrate the ratification of the 19th Amendment, which recognized the right of women to vote. Despite recent controversy, the Equal Rights Amendment has not yet been declared ratified. What are the similarities and differences between the two amendments? What impact, if any, has the 19th Amendment had on women in achieving equality with men in the United States and around the world? What are the advantages and disadvantages of states passing their own equal rights amendments rather than ratifying a national constitutional amendment? You may begin.
In early American history, women were denied many basic rights that male citizens enjoyed. Most women couldn't vote and were expected to focus on motherhood and housework, not politics. Throughout history, there have been many women who advocated for women to have equal rights. Abigail Adams was one of the first, advocating for women's education and property rights. She believed women should do more than simply serve their husbands. During the mid-1800s, women's suffrage was brought to the national level. Leaders like Susan B. Anthony tried to get the 14th Amendment to include suffrage for women. One factor working against this movement was that some male anti-slavery leaders refused to support suffrage for women. In 1869, Wyoming was the first territory to give women the right to vote. Many Western territories expanded the franchise to women to help gain population. By 1918, more than half the states had enfranchised women. Pressure for a women's suffrage constitutional amendment grew during World War I when an influx of women entered the workforce. Over the next 2 years, there was a national campaign that included parades, demonstrations, and civil disobedience in Washington, D.C. In 1920, the right to vote was expanded to women through the 19th Amendment, which forbids the government from denying the right to vote on the basis of sex. As of recent times, the Equal Rights Amendment has been proposed to be added to the U.S. Constitution.
The Equal Rights Amendment and the 19th Amendment possess many similarities and differences. Similar to the 19th Amendment, the House of Representatives and the Senate passed the Equal Rights Amendment with a 2/3 majority and sent it to the states for ratification. However, the Equal Rights Amendment is not part of the United States Constitution. Both the 19th Amendment and the Equal Rights Amendment advocate for women's rights, but the Equal Rights Amendment covers more than just suffrage. Section 1 of the proposed amendment states that equality of rights under the law shall not be denied or abridged by the United States or any state on the account of sex. This means that constitutional rights could not be denied on the account of sex. Section 2 says that Congress would have the power to enforce the amendment through appropriate legislation. The 19th Amendment has had a significant impact on women achieving equality with men in the United States and around the world. Women have been denied the right to vote for an extensive amount of time, and the 19th Amendment was a step towards equality with men. Women gaining the right to vote resulted in women having a say in their government. This played a pivotal role in promoting reproductive rights and social change.
Ultimately, contraception and abortion were legalized, family planning services were more available, and women were allowed to enroll in higher education to enter professional occupations. Women voted and eventually ran for office to improve not only the government but also their individual lives. Jeanette Rankin from our hometown state of Montana was the first woman to get elected to Congress and was the only person to have voted against American entry into World War II. Before 1920, only 15 countries allowed women the right to vote. The United States won women's suffrage ahead of several other countries like Britain, France, Italy, and Spain. There are many advantages and disadvantages of states passing their own equal rights amendment, rather than ratifying a national constitutional amendment. 25 states, including Montana, have inclusive or partial guarantees of equal rights on the basis of sex. Interestingly, 3 states with equal rights guarantees have not ratified the national amendment. An advantage of states passing their own amendment is that it reflects the idea of federalism and that state legislators have considerable power. However, to fully guarantee equal rights in all 50 states, a national amendment is required. If the Equal Rights Amendment was passed on a national level, laws passed creating classifications based on gender would be subject to the most rigorous judicial scrutiny called strict scrutiny. With strict scrutiny, the government must have a compelling interest for the law to be legal. Currently, issues involving gender are subject to intermediate scrutiny. We are now ready for your questions.
So, excuse me, I'll begin. Do you think that we should look at, for example, Montana's language and start fresh in terms of a newly proposed equal rights amendment, or do you think the one that's on the table now adequately addresses all the concerns that have been expressed beginning in the 70s?
So the Equal Rights Amendment has some advantages and disadvantages. One disadvantage could be that it could affect programs that would help to aid women, like STEM programs.
Yes, and I would say also another disadvantage is that, so when we mentioned also in our prepared remarks, our wording was from the 1970s amendment. And so since that time, laws have been passed that have aided like some of the goals of that original amendment, like the Pregnancy Discrimination Act and the Equal Credit Opportunity Act. So some of the goals have already been achieved, and that's led some people to believe that the Equal Rights Amendment isn't necessary. I think that the wording on the amendment itself is fine. I think an advantage of this, of the Equal Rights Amendment would be the fact that all 50 states would have equal rights, because currently there's 25 states that have equal right protections in their state constitutions, Montana being one of them. In Article 2, Section 4, it outlines equal protection of laws and also no discrimination on the basis of sex. And then again in Article 5, Section 7, where it details like educational and the fact that you can't be denied to a public institution because of sex.
Thank you.
Why isn't the Equal Protection Clause of the 14th Amendment enough? Why do we need something additional?
So I find that argument interesting because with the Equal Protection Clause in Plessy v. Ferguson, the separate but equal doctrine was established, and then 70 years later was overturned in Brown v. Board of Education. So the court kind of changed their mind on the interpretation of that clause, and with the Equal Rights Amendment, it wouldn't be left up to the Supreme Court's interpretation.
So what do you think? Do you think, you sound as if you're not thrilled with the language of the 1970s ERA, but do you think it should actually just be accepted by the archivist and registered as a new amendment, or not?
Well, that brings up some conflict because there was a deadline on the Equal Rights Amendment that hasn't been passed.
The deadline was in 1982, and there's debate over whether that deadline is constitutional or not, because the 27th Amendment was passed 200 years after, because it was one of their original 12 proposed, and there was no deadline set on that amendment.
I'm sorry, does Article 5 have any kind of a deadline in it, a date deadline in it?
I don't believe so, but so there's also some uncertainty surrounding the Equal Rights Amendment, because so recently 3 states have ratified that original amendment to bring the total to 38, because when it was original in the 1970s, only 35 out of the 38 necessary approved, but 5 states have also rescinded their ratification, so there's some uncertainty with the Equal Rights Amendment.
Do you think they're allowed to rescind?
I'm not sure, honestly. I think there's debate about that, and it's going to have to go through the courts, and the courts are going to have to decide whether or not that is constitutional.
So just talking about historical context, there was a stop movement in the 70s, which opposed the Equal Rights Amendment, and they had great concerns, single bathrooms, things, alimony, things like that. Do you think, looking at the situation through the lens of 2020, that some of the pushback from the 70s has already been addressed in other ways? Could you talk about maybe specific factors like the draft and things like that?
Yeah, so with the, oh, okay, so with the draft, so I was reading an article and it said that Congress has the power today to draft women and men, and that during the Vietnam War, they were actually considering drafting nurses, but that ultimately didn't happen. And so there's been debate, and I think one disadvantage of the Equal Rights Amendment could be that the Selective Service Act could be considered to violate the Equal Rights Amendment because it would be sexual discrimination.
Thank you.
So that's actually leads to a question I have. Is it ever appropriate for government to distinguish between sex or gender to make laws that treat the sexes or genders differently?
Well, I believe that obviously men and women should have equal rights, but based off of history, that wasn't necessarily the case because of voting rights and other stuff like that. Like Abigail Adams was one of the women who advocated for women's voting rights, and I believe that she paved the way for a lot of equality in today's life. And she was
Susan B. Anthony. Susan B. Anthony also paved the way for the 19th Amendment to go into the Constitution, which allowed women suffrage and the right to vote as well.
And I think also,
and she was a big advocate.
So today, gender disputes are subject to intermediate scrutiny, and if the Equal Rights Amendment was passed, they'd be subject to the highest judicial scrutiny. So that would be another protection with the Equal Rights Amendment.
And so what's the difference between those levels of scrutiny, I guess? What functional difference would it make?
So there, with the highest judicial scrutiny, there has to be a compelling interest or an important reason for the law that creates a classification to be legal. And that was in Craig versus Boren. There was a case.
You can finish your thought.
Oh, I was basically.
You got it. All right. Nice job.
Great job. Very good. Thank you. Ben, do you want to start? Or Marcia, are you starting?
I can start. I really appreciate that you started a long time ago. As we know, the word women isn't even mentioned in our Constitution in any particular powerful way, but starting with Abigail Adams and Susan B. Anthony brings the point home that this concept started pretty much when our country started, and it's still, this conversation is still happening now. So I really appreciated your timeline. I thought that was very effective to explain that this issue has been being discussed for quite a long time. I appreciated that you described what's in Section 1 and Section 2. I think that's really important for everyone to know what really is in this proposed Equal Rights Amendment. I, of course, appreciate that you mentioned Jeanette Rankin, so thank you for that. Mm-hmm. And I thought it was really interesting that when you were talking about this Elective Service Act, that you did point out that if the laws are imposed, neutrally, then there are some things where men might get a slight advantage in that, the pool of people who are drafted becomes bigger. So thank you for your thoughtfulness, your attention to detail, and especially the discussion about the level of scrutiny, because we lawyers know that that's a really important concept. And for you students, as high school students, to understand that too, that's pretty remarkable. So thank you. Good job.
I agree. Thank you, Marcia. I would second. I'm sorry, Ben, have I just jumped in all over you too?
It's okay. I'll jump in and let you close it out if that's all right.
Okay.
Yeah. So I would echo everything Judge Holland said. I appreciated the prepared remarks. A few things some nuances we haven't heard so far. The mention of World War I being one of the impetus for the 19th, I think, is an important point to make. And again, I'd echo the levels of scrutiny discussion. And if we had more time, I would have probed more. But it was clear there at the end that those weren't just words. You actually knew what it meant: strict scrutiny versus intermediate scrutiny, and the consequences that come with that. So I think that's great. And likewise, I like the notion that the 14th is not enough, because it's proven that judicial interpretation can vary with the 14th Amendment. And you gave that concrete example, not a gender-based example, but relevant by analogy, right? That it's the same principles that led Plessy to later be overturned by Brown could apply in a gender or sex related case. So I thought that was some sophisticated reasoning. I'm trying to think. Oh, and just strategic, we the people strategy, you know, the time was ticking, and Samantha, I commend you for making sure that you got in there, just like, get those twins, stop talking. I'm going to get in there. So that's good. Just, you know, we'd like to see everybody get in, and you made sure that happened. So congratulations.
Great. Well, thank you. Now, just to add a couple, I agree with my colleagues on every point they've made, but I also was very interested to hear you referring to the Pregnancy Act and the Equal Credit Act. Those were good points to make on your way to saying whether or not the ERA was necessary. But just, I hope this has been a fun experience for you all. I hope you've enjoyed working on this, and I hope it's inspired you to be the good citizens we hope you will be. Going out to vote every time you have a chance, and talking to your families and friends, dragging them along to understand what they need to do and what their responsibilities are. But more than that, I hope that you might think of being more involved in society and the civic life of the society than just going and voting. Because I have to say, you know more than anybody in my law school constitutional law class knew when I was in law school, and you're way ahead of the game, and I hope that if you're inspired to do so, you might be interested in representing us somehow, or being lawyers or judges, and doing something that involves or relies on your knowledge of the Constitution, because you've shown that you have it, and I look forward to being relaxed and sitting in my rocking chair at the nursing home, knowing that you're all going to take care of us when our old age. So thank you. It was a wonderful presentation. Appreciated it.
Thank you.
Bye, everybody.
Thank you.